This program is brought to you by Emory University.
My name is Paula Ahumada. I am a Chilean lawyer, and currently I am a doctoral student at Universidad Chile School of Law. While at Emory, as a visiting scholar for the Vulnerability and Human Condition Initiative, I'm doing my research and writing for my dissertation. After graduating from law school, I started working at a law firm, and where I had the opportunity to get to know other areas of the law very different from the ones that I've been engaged with now as constitutional law and legal theory. I worked in the areas of corporate law, mining, and industrial property. But while working at this law firm, I also was an instructor for the constitutional course at the university. So I always kept this connection with the academic environment. And at one point, I decided to pursue the academic path and career, and I started my doctoral studies, and I gained my master's degree at Duke University. I started with the tension between security and liberty that is at the core of the idea of rights and of constitutionalism and pervades the regulation over freedom of speech. That's my specific area of research. Rights are understood as these areas where we gain this freedom from interference from the state. And on the other hand, in our regulatory imagination, they are considered these things that we cannot not want, as very well were described by Wendy Brown. And freedom of speech is a very good example. Who would not want or like to communicate their ideas publicly, to express themselves with others? So it's almost counterintuitive to challenge this almost natural desire that we have. But one of the insights that a theoretical analysis of rights provided by Huffield has made has been that rights create these legal relations, and as they have these positive things, they also have the negative side and the harm side. For instance, the correlative for liberty is the no right. So if we expand the area of liberty, we want more liberty, it also generates for others certain harms. And that is why regulation is necessary. But of course, in the area of freedom of speech, we tend to ignore the harm side because we think that in the realm of persuasion, we are all equal. There's no real harm that you can make with words. This whole idea of words don't wound, words don't kill. So violence is many times overlooked. Of course, this will depend on the specific setting and the state of affairs that the society you are studying has. The main challenge that I have faced, I think that is one that many doctoral students have to deal with. That's the dilemma between being a hedgehog or being a fox. Like the hedgehog knows one single thing and the fox knows many things. But after you have settled the question that your research aims to answer, and that is also indeed a challenge, in the course of your research, you become involved in a whole idea of concepts. As my research is in the area of social sciences, we work with these concepts. And every time you, for instance, in freedom of speech and its interaction with collective goods, you first have to get an idea of what you understand of what you understand about rights, freedom, about collective goods, democracy, state, representation. So, and each concept involves its own sets of questions, of authors, of quandaries. And so in a sense, when you're doing your research, you engage with all these concepts. But the point is that you never have to lose the focus about the question that you want to get answered, you know. So at the end, in a way, you need the tools of the fox to become the hedgehog. Freedom of speech at first sight seems to be a very structured concept. We all have this ability to talk, to communicate. We all want to develop this ability, and the main threat to this liberty is the state. And it also has to do with the origins of rights. The rights of the individuals were born as against the authority, this divine monarchical authority, and a feudal system. And the conception of the rights has a lot to do with a conception of authority. And I think that, for instance, Waldron is right in the suggestion that he makes about that the theory of rights has to be connected with a theory of authority. Because now that the power has returned to the people, or so we like to think, that popular sovereignty is on the people, not on a divine authority, what is the role of the state? What is the role of the state for promoting these rights that the individual has? So that's one point, the state, and if the state can be a friend of speech instead of the enemy. And on the other side, the media, I think that the media are these hybrid institutions where the public-private distinction doesn't really apply, because it's a commonplace to state the importance of the media for democracies. But when we analyze freedom of speech in a concrete situation, for instance, the right of the workers to strike, to present their demands on the streets or social movements, they are exercising, well, the right of strike, but the right of freedom of expression. But they have no control on how this demand, X demand, is going to be represented in the public sphere. That's a power that the media has. So I want to understand how we regulate this power. My research is focused on a cornerstone of liberalism, that's constitutional basic rights, and especially freedom of speech. But also, liberal scholars have argued that freedom of speech is like a liberal puzzle or a problem to liberal democracy. So my aim is to understand these contradictions. For instance, liberal theory starts from the point of view of the autonomous rational subject. And I think that the vulnerability theory has provided a great insight in a very clear way, unveiling how this framework is blind to our differences. It's blind to the vulnerabilities we face in our lifespan, and how the vulnerabilities are created through the same institutions. So I think that the interesting point is using this theory to argue for changing the presumption against the state in regulating freedom of